Hafade Zan Mananasizuis. Thank you all for being here today. I know it's bright and early on a Monday morning, no less. The Guam Trademark Commission will now be called to order. For the record, in accordance with the open government law, meeting notices were given to all commission senatorial members, stakeholders, and all main media broadcast outlets. The first notice went out on Monday, August 19th, 2019, and the second notice went out on Friday, August 23rd, 2019. Today is Monday, August 26th, 2019, and the time is now 8:44. We have 7 members plus myself, which represents a quorum. Today's meeting is the Commission's third meeting. There are new faces present for today's meeting. For those present, the Commission's last meeting was held on June 26, 2019, and by law, we are required to meet once a month. And when the legislature completes the fiscal year 2020 budget, we may be able to establish and set a routine meeting time. Before we continue, I want to ask those who have been appointed to represent their agency heads to please fill out the commissioner enrollment form or who were appointed by others. So, does everyone who needs one have, it looks like this, titled commission member. So I can pass one out if needed. Found it. Okay, great. Commissioners and alternates that filled out an enrollment form at the May 6th and June 26th Guam Trademark Commission meeting are not required to fill out the form again. The enrollment form is necessary for the Commission to contact physically or electronically any commissioner or their alternates so that everyone becomes well informed of the Commission's activities. Again, I want to emphasize that agency representatives may deliberate or make decisions on Commission matters that could very well affect or impact their organization. Please submit your enrollment form before leaving today. We are now on item 2A of the agenda. Please reference the Guam Trademark Commission enabling law provided to you, specifically section 14105B, items 1, 7, 8, and 9. So at our last meeting, we had informed discussions provided by GIDA, the Department of Revenue and Tax, and CAHA. GIDA and the Department of Revenue and Tax provided a cursory overview of the Guam Product Seal, the use and/or application of trademarks within the regulatory and programmatic applications as they currently exist in the government, the process for certifying artists, the process for certifying art organizations, the process for certifying vendors. These discussions, of course, will continue as we look deeper into these issues. For CAHA, they began a listing of different categories by providing a listing of the masters that have been awarded thus far and the types of categories that they represent. So specifically, we looked at types of cultural arts, including intangible arts. These discussions are useful as it provides informed and meaningful direction for the Commission to move forward in creating the framework and the scope necessary in drafting the Guam Cultural Trademark Act and the Guam Trademark and Intellectual Property Rights Act. This morning's discussion on item 2A of the agenda will be on the identification of intangible arts. So with that, the CAHA representative who usually supplies such information was not able to be here today. They have conflicting other meetings that are happening this week, but we will continue to work with them so that they can be continuing to build up that listing of cultural arts. We are now on item 2B of the agenda, which is, oh, well, that's B. In A, we still have 7, 8, and 9. So let me revisit those and just see if we have anything additional to add. For Gita, I know that you did a good job in describing these the last time we met. Is there anything to add at this point to 7, 8, and 9? The proposed process for certifying artists or our organizations or vendors?
Not necessarily, Senator, but one of the questions that did come up was when we look at the law and we look at item B, which was the Guam Cultural Trademark Act for cultural arts manufactured or produced in Guam, one of the questions that came up is, are we only going to concern ourselves with products that are going to be available on the commercial market? Is this only going to be for products that are sold either retail, it's art, so retail, or if they're going to mass produce a piece of art, they're going to sell it wholesale? Or is the commission going to extend it that if anyone wants to say that this art, even if it's going to be a gift or just a donation or something, that it needs to have some sort of trademark? Because remember, the Guam product sale deals only with commercial products. And it's based off the price of the product, transformation of the product, and the value added. So that was one of the things that came up in our discussions back at Gita about when we certify art, are we only certifying commercially available art or personal art or anything like that? Because like I said, remember, the Guam product sale already in the rules has an exemption saying if it's like a piece of art, it doesn't need a Guam product seal unless they want to explicitly say it's made in Guam. So if someone's just going to make art and say, oh, I painted that or I carved that, they don't necessarily need to get a Guam product seal all the time. But there is a little gray area between individual pieces of art and maybe mass-produced art. So that's one of the things that came up in our conversation.
Sejus Maasi, for continuing to be discussing this and working on this with your colleagues. And I think you brought up a very good point. I think, and this is where our presentation today and our member from the Attorney General's office, Ms. Stacy Salas, can provide us some guidance, as well as some of the other members here. So it's my understanding that we want to be creating something that can apply to either situation. The very little bit of experience that I've had with artists and people who've worked with artists is that some artists in particular do hold or claim that intellectual property right over the art. Whether they produce it or not, it can make a difference as to whether that art becomes part of an exhibit later on, whether somebody later on is interested in mass producing it. So I think that's a very relevant question and a really important topic for us to be looking at. Will it automatically apply, or is this something that one has to apply for? And what protections will happen naturally or solely with applying for and achieving some sort of protection through an application? So again, thank you for looking at that. Did anybody else have some thoughts on the issue? So these are the kind of questions that are really important for us to continue to be thinking about. And we can't get all the questions at the table the first time around, because these are things that as we continue to meet with others, as we continue to read or find material that serves as resources, as we continue to just think about these issues, we'll find that we have questions like this that'll come up as pertinent. And so there, that's is partly why we're taking our time going through the process and having presentation and issue and situation per meeting, so that we can feel like we've really thoroughly exhausted and explored a lot of issues before we get down to some of the actual policy development. With that, we can move on to B. I believe CAHA has provided some definitions of art forms. And so what we can do is we can work on that as an office and then make sure that everybody gets a copy of it. And they did put draft on it so that it's something that we can be, from our different areas of expertise or understanding, be working on together. With that, I do want to throw out in the old business as well. The CAHA board representative, Mr. Frank Rabone, had talked, as did some others, about intangible cultural heritage, the intellectual property rights, and what people could do before we finish our work here. So I just wanted to let people know that I did reach out to the UNESCO Intangible Cultural Heritage representative, and she has referred me to somebody in Paris who deals with U.S. territories specifically. So I'm still waiting to hear back from that person, and I'm going to have to follow up again. But I think it is important that we reach out to people. And just to point out, this is really maybe kind of sort of new business, but just to let people know, if you hadn't heard, there is an intangible cultural heritage workshop going on in Tonga, I think, very shortly. And so those kind of workshops and gatherings go on quite often in areas around us. And so we might want to explore the ways in which we can touch bases with some of that or participate in one way or another with some of that work. So for new business, we'll go ahead. We're pleased to have Ms. Stacy Salas from the Attorney General's office. And as I've mentioned before, each and everybody's presence here is so incredibly important because you each bring such valuable information and experience to the table. And that, I think, is a really important part of this legislation and the way that it was written. It was very thoughtful in that way. So I'll go ahead and turn the floor over to Ms. Salas, and I'll be taking notes along with everybody else.
Awesome. Thank you so much, Senator Marsh. Taitano, Hafide. I'm Stacy Salas. Good morning, and thank you all for your time. I hope everyone had their coffee. Oh, okay. I'm going to do a presentation on the Guam Trademark Commission Act only. I'd like to provide a roadmap and sort of the expectations of this presentation so that we can digest and absorb the information. This is a huge, comprehensive type of law that we're dealing with respect to intellectual property rights. It's a whole world in and of itself. And so the roadmap here is, how did this law come to be? So the background and history. What does the law say, so that we can sort of get into the teeth of it and start, moving the dial forward from the previous meeting, and sort of what did the legislators point us to direction-wise, right? Because there's a Maori sort of their laws that we can look towards, so we don't have to necessarily try to reinvent the wheel. So that's the roadmap. And the expectations for this presentation is we are going to just cover this law. There are many sections, and so it is just not realistic, and I'd like to reduce the level of confusion as much as possible. And so what we're not going to cover are the other laws that are on the book. So we have criminal statutes pertaining to trademarks, we have a current civil statute, and then, of course, as Gita knows and everybody does, there's the Guam product seal. So we're not going to cover that. So go ahead and put that in their little bins right now. But what I want to do, if you guys want, is in the future meetings, we can cover each law. There are way too many sections, and so I think that, and we ran through my presentations because I already have them at the AG's office. And so, and we're all lawyers, so if I'm gonna present on all the laws, it's overwhelming, and I think it just gets us off track. So if you guys have any comments at this point, we can make them. Otherwise, I'd like to try to get through the presentation entirely, and we can hold off on questions, and you can make notes of them as we go. And then ask them at the end. I'll try to answer them, and if not, of course, then I'll take them under advisement or ask for a written request, because that's really the most effective way to communicate what you're asking and how I'm going to answer it. And of course, I'm going to have questions, so when I ask a question, please participate. That's different. That one is, for us to really start thinking about these items and, as I mentioned, move the dial forward. So that's the roadmap and the expectations for this presentation. And so if we can go ahead and, awesome. So this is the first slide. Again, it's the presentation on the Guam Trademark Commission Act, and I did receive a written request on all the trademark laws, but so then we'll do that as we go along. This is a huge endeavor, so I'm glad everybody had their coffee, and if not, please take the time to do so. Okay, we're gonna move to the next slide. Legal disclaimer, of course. This is sort of akin to a legal class. I'm only gonna give you the framework so that you guys can sort of know what the law says, what you guys are supposed to focus on. Like my dad says, focus, Stacy. So this is not legal advice. Legal advice will arise when there's an issue, like a real something on the ground. And then it doesn't create an attorney-client relationship with any individual GovGuam employee, entity, people in the room. So please know that the relationship is between the Attorney General's office and the commission. And anything I say here today is my opinion. It is not the opinion of the Office of Attorney General, so please, whatever I say, just direct it to me, and I'm not making a blanket statement for the office. All right? So we're going to move to the next slide. I want to open the floor to sort of the core of why we're here. The essence of it all is generally, not in the legalese fashion, not like in the 10-page or however many pages, even the U.S. federal law explains what a trademark is. And I don't know if it's 10 pages, I'm exaggerating. But I wanted to open the floor, and so this is where you guys can participate. Does anyone have an idea of what a trademark is, generally? Okay. Do you want to go on the yeah. Let's participate. It's going to make this more fun.
It's a mark or an idea or something that you want to claim a right to.
Okay. A mark or something that you want to claim a right to. Okay. As the creator of something. Okay. So it creates an ownership right or acknowledgement. Anything else? Okay, so that's all right. Basically what a trademark is a symbol or, and we'll go to the next slide. Sorry guys. It's a symbol or words used to represent a company or a product, right? So when you see a check mark in the sports field, you're probably more than likely going to think of what brand? Does anybody know? Nike. Okay, so that's trademark. It's a symbol with respect to Nike that represents a company or a product, athletic products, sports. Okay, and then, awesome. So this is where we're going to talk about why is trademarking important. And before we get into it, I'd like to illuminate the importance of it through this exercise. It's kind of like a pop quiz. And it's not in your presentation because it was kind of thrown in toward the end of it. So we're just going to stay on this slide. And what I'm going to do is I'm going to pass out this pop quiz. And it's going to illuminate the importance of having a trademark symbol because more often than not, we're able to associate a level of value with a symbol. And that symbol that we've seen many times, we can determine whether it's a real item or a fake item. So if you see a Nike check, but the check is not the way that you've been socialized to see it over time, you can tell that it's fake. So everyone's gonna get a page, but what I'm gonna do is split us up in teams. So from Senator Marsh, Taitano, to my side of the table, we're gonna be one team. And then the other end of the team is gonna be another team. So we're gonna be in 2 teams, and whoever gets the most correct is the winner. So we're gonna also name your team, so think of a team name, okay? So the object of this pop quiz is to be able to look at the symbol and designate next to the symbol whether you believe it is a true trademark symbol or a fake one.
When you say a true trademark symbol, do you mean one that is utilized? Not one that could serve as one that is actually used?
Yeah. I mean, just very simply, do you think it's real or fake? So
Okay.
just go ahead and note next to the symbol if you think it's a real or fake symbol.
So what I do with team names is sometimes, and we're free to go in our own direction, but I'll have a team A and the other team A so that nobody feels like they're not part of the A team.
And so I'll give you guys time. Please work together, if you have any ambiguity. And then when you're done and you have your final. Yes, ma'am. Did anybody not get one? Okay, everyone has one. When you're done and you have your final answers, please submit them or let me know. Just raise your hand and I'll come by.
Stacy?
Yes.
Just to clarify, trademark, is that not also like a brand?
Yes, yeah,
Yeah.
it's a brand. And when we're talking about it generally.
But
So-
it can be a tangible brand or it can be a conceptual brand, correct?
I'm not sure what you mean by tangible or conceptual.
Well, tangible is Coke, right?
Yeah,
Is it Nike,
yeah.
Nike sneakers?
Okay.
Or shirt or whatever, and the brand used therein. And then there's also the conceptual brand, which is like a signature service product.
Okay.
Or I'm thinking, for example, of our own company. We've trademarked some of our signature products,
Okay.
which are not tangible, they're intellectual,
Okay.
right? So that can also,
Yeah. Yes. So I'm not an expert in the trademark world, but yeah, I think
Yes.
that, for the purposes of this activity, however you view trademark, my goal is just to see if you guys can identify whether it's real or fake.
okay,
So whether it's conceptual or tangible.
or tangible.
You got to stick with your team.
So Stacey's our
Okay, guys, let's give it another minute and a half and go ahead and just enter your answers. It's okay, we're not gonna get grades.
So are we ready to give our team thoughts? Oh, am I supposed to be putting enough there?
Come on, guys.
What's our team name?
Okay, we have the Taitano that won by 1 point. Okay. Yes. Taitano just lost by 1 point, but everybody's a winner here. Yes, the Jordan one is not real. So it's,
Is it his fingers?
I mean, sorry, the Jordan one is
Oh.
real. Oh, the Starbucks one? Oh, wait, is not real. Sorry. Yeah. So you guys thought the Coke one was fake. It's real. You thought the Adidas one is real, but it's fake. And the Starbucks one is also fake. No, the Starbucks one, the star above the mermaid is supposed to be filled in.
Ah, so are you saying that the Crust toothpaste is not real?
Yeah, crust is not real.
Yeah, no.
It is. Yeah, it's probably just a zoom in for the like trademark symbol or something. It's okay, guys. So the goal of this is to illuminate this confusion, right? Or like your ability to, for the most part, identify what's real and what's fake. So everybody's a winner. I'm going to pass around chocolate if you want some. Those are real Ferrero Rocheros, whatever they are. And so I did this exercise because I wanted to show how we do identify certain symbols with a company or a product, and that's what the commission is trying to do, is to come up with a symbol to identify with a product that's authentically Chamorro, a Chamorro cultural art. How many of you think that someone off the street can identify if something is a Chamorro cultural art? So for example, we just picked up, a cup and it says half a day. How many of you think that someone off the street will know whether or not it's authentically Chamorro? Okay, none at all. Yeah, off the street. No, not a master, but someone just off the street. Okay. And most of you were able to identify a lot of these brand names. And so the commission is trying to create a symbol that allows people to distinguish between what's authentically Chamorro, a Chamorro cultural art form, and what's not. And so yeah, well, you guys will come up with it, but you'll want to create the trademark symbol for the Chamorro cultural arts. Yes, art form. Yes, well, and that's what you guys have to determine. Well, the statute says Chamorro cultural arts. So although...
And states, who would be the organization that will issue or dictate or determine that?
That's a good question, you guys. I don't know. We have to start with what the statute says and then create subcommittees, right? Because if everybody tries to chime in as to like what we need to do, and we're not tracking it or we're not being held accountable to how this system is going to work, then it's going to be all over the place. So that's a good question. Who? And as we go along, people can volunteer based off of their expertise, or we can sort of delegate, right? So the goal of this commission is to one day be able to put on this pop quiz a Chamorro trademark symbol and have people able to identify, oh, that's actually something made by a master blacksmith or somebody who was an apprentice at some point, or somebody who comes from a family, not a biological family, but a family of artists who have experience and a background in this type of work, art form. And so, yeah, thank you all for participating. I do have some items that I came across. I'll pass it around just to have some kind of tangible example of some of the things that are coming out that have been trademarked federally, but don't have a Chamorro cultural symbol on it. And whether or not they want to have that, that's a whole nother conversation. But I'm going to pass it around just so that we can get more of a feel for what we're trying to do here as the commission. So these laws stem from issues that occurred with Kmart. So I went to Kmart and I looked at what they have, and this is an item I'm going to pass around. You can take a look at it. I don't see a trademark symbol on it, but you can look at it and see if it has any likeness to things that a local artist could have made and could have probably made money off of selling it themselves as an authentic Chamorro cultural art. I have a book here that came out, 13 Months in Malesu. It's put out by Yoji Press, and they do have it copywritten federally. And then some coasters that I found at Kmart as well. They have symbols on them of just local art. So you can see the type of things that you guys sort of have the power over, right? When these artists or entrepreneurs, I watched the last meeting, what they come out with, and sort of if they're able to stamp this is an authentic Chamorro cultural art, how people can distinguish between who made it and who didn't. So that's just to go around so that we can have some kind of, I'm like a multimedia kind of learner, so go ahead and look at those things. And while we look at that, I want to move forward to the next slide. We went over that it helps us to distinguish between what's real and fake. People spend their money expecting a certain type of quality or value associated with it. How many of you today would purchase an Apple computer without the Apple on it? How many of you have purchased an Apple computer? Anybody here? Okay. And you wouldn't purchase it if it didn't have the Apple on it?
Right.
Why not?
Because it would perhaps signify that it's not authentic and it doesn't have the actual technology and the guarantee that I would expect.
Okay. So if it had a banana on it, you wouldn't buy it? And they told you it was an apple? You wouldn't buy it?
Okay, correct.
Okay. Okay. How many of you have bought Jordan tennis shoes for a family member? Does anybody know? Okay. How many of you would buy it if there was no Jordan symbol on there? If there was no Jordan symbol? No? Why not? Why wouldn't you buy it?
My grandson would not accept it as a gift.
Why wouldn't he accept
Because
it?
they're into symbols and brands. They want to be associated with the Michael Jordan brand.
Okay, okay. And so that's kind of the goal with what the commission is trying to achieve, is to say, this is a quality Chamorro cultural art. You guys are going to determine what the criteria is, you know.
Stacy, can I clarify again
Yeah.
for the record? Okay, because the law states uses words like local,
Yeah.
Guam,
Oh, let's
and
point to
Chamorro.
which part of the law names local.
Okay, well, here in your slide
Oh,
relating
okay.
to.
All
okay?
right. No, that's fine. So
Yeah,
that's in the.
we just want to clarify, what does the law require?
Yes.
For Chamorro
Yes.
tradesmark, or for local tradesmark, or for Guam tradesmark? Because those are three different things.
Correct.
right?
And we're going to keep, you know, working with this, these concepts. So we can go ahead and move to the next slide. So where did this law come from? So in 2013, part of the background and history of why the commission came to be is that we wanted to revisit the current statutes that are on the books. And so what we're talking about with respect to the word local is that word is in the legislative intent. It's actually not in the statutes, unless, and someone can correct me, if you see the word local in the statutes, which is the law, the legislative intent is sort of, you know, the conversation around why we needed the commission. So local is found in the legislative intent, but it's not in the statute. So we can go ahead and move forward to the next slide. So the legislature wanted to say we need to revisit the laws that are on the books, which are the Guam Patents, Trademarks, and Copyright Law. That's the civil law that we have on the books. And they also wanted to note that the Guam product seal is not what we're looking for. It's good to provide some kind of regulatory accountability for what's created here. But the essence of what the commission is supposed to do is try to protect, well, there's two pieces, general trademark law as well as Chamorro cultural arts. So not just necessarily made in Guam, but made by or made in some kind of way. That's what differentiates it between the Guam product seal and what we're trying to do here. So we can go ahead and move to the next slide. Okay, so a huge impetus for the commission was also the preparation for FESPAC in 2016. Chamorro arts was going to be displayed in a way that was sort of unique in that it was going to be here at home, and there's more access for artists to show up and show what they have. And does anyone know any of the concerns that some of these artists had maybe in showing their art without some kind of trademark symbol? Does anybody know any personal stories by artists that they may have been hesitant to show what they know because they didn't want it to be copied or some kind of, because I'm not an expert in the background of this law and why it came about, but folks can chime in and sort of talk, we can talk about.
Most of us are in that predicament already.
Okay.
I consider myself an artist, so yeah, we feel the same way because nothing has transpired in order for us. So some of us are not that readily easy to avail our artistry to, especially to visitors as well as to, because we're not protected.
Okay.
And right now, as it stands, anybody can take what we design, what we create, and manufacture it all over the place and produce it. And I've seen it. I've seen pictures of my dancers being used as a candy wrapper, okay, at the duty-free show. And I had to go over there and tell those people they either remove that candy wrapper or they start paying me royalties because those are my dancers on that wrap. And you never ask permission to use that picture as your candy wrapper.
Okay.
You know, and that's a
Thank you
personal
for sharing.
experience.
Appreciate that.
Yeah.
I think the other example would be the Surahana or the Zoamti. You know, their practices. I know that that was a conversation and an issue about, how much they share, just how much they would share or not, how much,
Yes,
like on the
yes.
surface, because some of it is not, it's not so much that it's, again, it goes back to intellectual knowledge and also of our people and our ancestry.
Yes.
And so how much of that do we really want to, put out in this kind of art, or if it's going to be commercialized? And so I know that that was one of the biggest things, not just during FestPac, but even as soon as the whole thing on Zomti and Sirohana, has been expanding, that's becoming an issue of the Manamko not wanting to share all of their knowledge, right? So there's boundaries also. There's cultural boundaries that need to be respected in this world, in this Western world of us trying to commercialize everything.
Gotcha. Yeah, so this is good because, that's why we're here today, is to try to come up with, if not the answer, right? Because the answer probably lies a little bit further out, but what are the components on the ground? So we named, the medicine and the dancing, right? And we're talking about art forms. So whoever is interested in, the categorization, I know that we mentioned Kaha already, so that's good. But I just wanted to open the floor so that we can sort of remember again why we're here. Okay, so we'll go ahead and move to the next slide. What is the commission supposed to do? It's a huge endeavor, huge, huge, huge. It's going to take lots of time. And so this is in section 14102. You guys are supposed to develop policy and recommendations to the legislature regarding, I'll read this off so you can get sort of the expansiveness of what you guys are supposed to do. So recommendations regarding the coordination, planning, implementation, administration, promotion, compliance, and enforcement of, now this is a really critical piece, right? 2 trademark laws. So number 1, we have the Guam Trademark and Intellectual Property Rights Act. And number 2 is the Guam Cultural Trademark Act. Those are the 2 laws that are named in the statutes, right? So I know that in the previous meeting, Senator Marsh Taitano mentioned maybe creating committees, separate committees to tackle each endeavor. Or, based off of whatever the resources are, it's up to you guys to figure out maybe the essence of what we're trying to move forward. It could be the Guam Cultural Trademarks Act,
And again, Stacy, I asked the question because Guam Trademark and Intellectual Property Rights Act applies to the whole
Yes.
island and to all of the participants
Yes.
on the island. Guam Cultural Trademarks Act, but within that, there could be a specific component for Chamorro trademarks.
Not necessarily
correct?
within it, but I think based off of section 14105, it's going to be a separate act.
It's going to be a separate act.
Yeah, that's from my understanding. It's how the statute is written. You have to make one Guam Trademark and Intellectual Property Act and one Guam Cultural Trademark Act. And if you have the law in front of you, we can go to 14105. So it says the commission shall work collaboratively to create policy recommendations, rules, and legislation for 2 specific areas in defining and developing a Guam trademark law. It says a Guam trademark law, but then it goes into 2 different laws. So I guess you're right. If you guys decide that it's a general one, and then within the general, you do Guam Cultural Trademarks Act, or, if that's where the recommendation part comes into play, if you guys want it to be 2 different acts or one within the other.
Or a Chamorro component.
Yes.
Because Guam and Chamorro are not synonymous in this context.
Okay. Yeah.
So,
And that's something to make note of with regard to your committees, right? How is this law, how would you recommend that the legislature structure it? Because we're at the point of just trying to be as creative as possible, but also simplistic so that it can actually work on the ground, Once we start putting it up in the stars in the sky, forget it. Okay, so then we'll go to the next slide. So those are the 2 laws that you guys are tasked with working on. And then we'll go to the next slide. You guys know what the makeup of the commission is. There are supposed to be 11 members. So we'll go ahead and move on to the next slide. And then subcommittees. You'll want to create those or form those at some point, right? So folks that work on visual arts, performing arts, literary arts, traditional arts. And this is language from the statutes. And those subcommittees can help with determining how are you guys going to come up with qualifications for what warrants the trademark symbol and what doesn't. Okay.
I just wanted to point out that, when this was written, there was maybe a certain thinking involved. We were getting ready for the FESPAC, I believe. That's how FESPAC divides up their committees into these 4 art disciplines. But we had talked about, for this commission and the things that it needs to do, perhaps we would think of other ways to form subcommittees rather than just the 4 art disciplines, because we have people with marketing background, legal background, and other backgrounds. And so there might be ways that help us move forward more effectively. Yeah.
Yeah, so in formulating the subcommittees, you're supposed to recommend to the legislature how this will work on the ground. So that's important to think of going into it as a form of just as a recommendation, right? We don't have to necessarily constrict the imagination to the statute. I mean, you want to stick to the statute, but, sort of let them know there may be, room for other subcommittees or art types. So, okay, that's good. So we'll go ahead and move to the next slide. Okay, you guys know that you're supposed to have monthly meetings. Simple majority constitutes quorum, and then in order to take an action, it has to be done by a simple majority as well. So we'll go ahead and move to the next slide. Okay, so the Guam Trademark and Intellectual Property Rights Act is, supposed to be created as it relates to U.S. trademark and intellectual property rights, to U.S. trademark and intellectual property rights. So I leave that to you guys. There are federal statutes, and that there's not much in the Guam Trademark Commission law that we have guidance on with respect to this act. You can look at the statutes. This is probably the only guidance I found for this act. And then we'll move to the next slide, where I think the meat of the work is, which is the Guam Cultural Trademark Act, right? You're supposed to create something to promote and license Chamorro cultural arts manufactured or produced on Guam. I know there's been conversation as to whether or not you're constricted to or restricted to manufactured or produced on Guam. Again, I don't think it hurts to follow the law with respect to recommendations to the legislature. You'll want to make your subcommittees accordingly, right? Based on each issue that arises. So we'll be working on this for a while. Don't think that we have to produce this tomorrow. I mean, it would be nice, but. So the commission can gather information, conduct research. The statute provides that you guys can obtain professional services, including legal services, conduct polls and surveys. So we'll go ahead and move on to the next slide. I think this is a part of the huge items and maybe how you want to structure your subcommittees. Who's best suited or better suited to identify a cultural art and help with the criteria creation, right? So if you're going to buy an Apple computer, somebody said you need to have the Apple logo on the computer. You need to have it, right? So start with maybe what does the Chamorro trademark logo look like, right? You want to have a logo. And lineage of cultural knowledge, I'm not quite sure what that term of art is, but if we go on, continue with the Apple computer analogy or metaphor or comparison, Apple has its own lineage. So each computer will tell you this is a 2.1.2 and this is like a mountain lion version. And let me know if somebody is not familiar with Apple products, because I can also switch it to something else. I just like Apple because it's, you pay a pretty penny to have an Apple computer, and so then that marking of the Apple is very important because you expect certain things from it. Authenticity. How are we gonna, who is best suited, to make those determinations on what's authentic, level of quality? I leave that to you guys. Cultural content, and the legislatures created these different categories, but it does say in the statute that these items should be discussed, but you're not limited to them. So if something else comes up with regard to how are you going to certify something as a true, authentic Chamorro cultural art, if you have some other type of criteria, you're not prohibited from, coming up with other requirements. And I'm sure Gita, talking about the Guam product seal, they have their requirements. So that's an example. We can go to the next slide. You guys are looking to create the criteria for the proposed trademark image. So whoever's excited about that should work on it, because some people are going to be more excited about the process of certifying something, the symbol itself, and quality control, et cetera, et cetera. Come up with a process, as I mentioned, and the proposed terms of use of the trademark. It's all pretty general, pretty big, so over time, the hope is to be able to narrow and have actual language for what does that mean. Okay, I'm gonna move on to the next one. All right, so again, going back to the idea of not reinventing the wheel, the legislative findings and intent point us to the Maori folks in New Zealand. They have their own program. And so it's called Toi Iho. So I would recommend going to their website. They do have a registry for artists, et cetera, et cetera. It's a very good place to start. All right, we'll go to the next slide. Oh, I do have a video for you guys, so that it'll take some time to pull it up. But I just wanted to play. I know everybody's seen it, but I still think just to sort of wrap it all up and close the loop, that we should watch at least the first 3 minutes of this video. And then that's it. That's all I have. After that, I'll have the logo that the Maori folks use, and then that's it. And then we can open the floor for questions. And you will notice in the PowerPoint presentation with the symbols, they've made different symbols for what's Maori made, like fully, and what's been a collaborative work. So there's different symbols that they use, which is an idea that you can recommend to the legislature.
Suzuis Masi, Stacy, for your presentation.
No problem.
It was interactive, it had games and candy, so I vote that you do all our presentations and walk us through everything. But Suzuis Masi, for all the thought that you put into it and really helping break it down for us, certain elements that we hadn't yet discussed or maybe fully understood, so it was very useful in that way. So maybe what we'll do, since we do have session going on very shortly, is think about the questions, maybe write them down, but watch the video and then see if we can adjourn, and then take a lot of this food for thought into our next meeting. That should be coming up somewhat shortly. And we've talked about going through the different processes. So maybe we could have the presentation on, where'd that go? On the Trademark Counterfeiting Act, or do you think that would be getting too much into the weeds at this point?
Up to you guys. I can do the presentation, or we can sort of try to, or you guys can dive into the meat of. You guys can decide. We can do the counterfeiting presentation, or up to you guys.
Okay, yeah, because the way that we've been approaching this is kind of getting to understand the landscape.
Okay.
Some of what's out there, and then But we are thinking at the same time about subcommittees and so forth. And so I think you really helped us in some of those areas.
Do you guys
But-
want to know about the counterfeiting, like the criminal statutes that we have now, or the civil one, the Guam Trademark, Patent, Trademark, and Copyright Act?
Right, and that one might be the more natural next step.
Okay. All right, the civil one. Okay.
Great, so we have that to look forward to.
Okay. So I'm not sure if the video is. All right. Awesome.
To me, Toi Iho means the very core, the essence of Maori art, where it comes from, its origins, its narrative, its histories, what we call te taikaka. That is the heartwood. That when you carve something, you are carving at the very heart of the principles of tahungatanga, which all our great artists have been imbued with by their people and by the deeds of their forebears.
The Toi Iho Maori-made mark is a registered trademark of authenticity and quality for Maori arts and crafts. Maori artists will use the mark on works they produce. The mark will be used in the form of a label, sticker or swing tag attached to works for sale. The mark has also been designed to authenticate exhibitions and performance of Maori art. Maori artists will need to apply to Te Waka Toi in Creative New Zealand to become licensed users of the mark. The mark is a For Maori by Maori initiative. The mark has been created by Maori artists. Some of the artists involved will now explain why the need for a mark and what it's all about.
Is there a need for a mark? I actually think that within Te Ao Māori, particularly at this time in our arts development and cultural so-called renaissance, there is a very real need because so much of our imagery, so much of our taonga, so much of our beauty has been pillaged and exploited and replicated for us in places like Taiwan, the Philippines, Korea.
Seduas Masi for that. It's important, I think, to go back to that video from time to time, and I'm glad you suggested going to the website to look at their actual registry, because it is so much to absorb. I think every time I see that or that video, or when I go to the website, it will sink in a little bit further each time about what, all the processes, all the ways to think about this that we're really taking on. So for the questions, if we can put those down and have them ready for next time. And then we'll have that presentation. So Seduas Masi for being willing to provide yet another presentation. That one being on the patents, trademarks, and copyrights that are presently part of our Guam Code. So with no further items for discussion at this moment, can I hear a motion to adjourn? Do I hear a second? All those in favor? Motion carries to adjourn this Guam Trademark Commission meeting at The time is 9:44. Sijuas Masi, everybody. I think it was a very productive morning, and it's wonderful to have you all here. I look forward to our next meeting. So Sijuas Masi, and we're now able to get on with our day.